in our group. We have members from Sri Lanka, Nepal, India, and Bangladesh, to mention a few. We share progressive ideals, and we go on with a sense of social justice and democratic ideals. So now moving on to today's topic, what is it about daring to disagree? What is it about the new criminal codes? So on the 1st of July, this is the most important time. Maybe this is probably the high time we have a discussion on this. So on the 1st of July, we had the three codes coming into force, namely the Bharatiya Nyaya Samhita, the Bharatiya Nyaya Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam, BSA, which replaces the old IPC, CRPC, and the Evidence Act, respectively. So with regards to what is the connection between democracy and these enactments? So laws tell a lot about the society, especially the penal laws, because they directly deal with life and liberty of people, the citizens especially. So it actually is a direct reflection of the society. And when we come to the passing of these bills in the parliament, we saw that in the month of December 2023, we had almost 150 members of the Lok Sabha being suspended in the opposition side. That is when the bill was actually passed. And then further, one of the important reasons given by the government to bring in these enactments was that this would replace the old colonial legislations. But it is unfortunate, it's surprising that they have retained many of the provisions which were there, the provisions which we expected to be gone, like sedition. Sedition was struck to be unconstitutional, but it was retained in another form in section 152 of the new BNS. So these are a few things that I could notice. Now we would open it for our speaker Manu to actually go further and discuss. Yes, Manu, you can.
Good evening to everyone, and thank you, Prochita, for that introduction. And I'm also very happy to hear about the Progressive Students Group. It's very exciting and very reassuring to see students, young students like you. You are taking up causes, social causes, and questions related to constitution. So we often see youngsters only focusing upon their own careers only, and without being concerned about larger social issues. So it's very, as I said, it's very reassuring to see students taking up progressive causes and acting with a sense of social commitment. So coming to the, excuse me, I have a slight cold, so the sound is a bit, so just excuse me for that. So coming to today's topic, so we are discussing the impact of the new criminal laws on the scope of dissent in our democratic setup. So as Prochita was saying in the introduction, the government brought in these laws with a propaganda, I would say, that they are going to decolonize the criminal law system. Yes, it is true that the Indian Penal Code as well as the Indian Evidence Act, they were enacted during the times of the British rule, and the CRPC came in much later in 1973. And of course, there are many problematic areas in the IPC as well as in the Evidence Act, which needed revision and which needed updation. Nobody is saying that criminal laws had to be static. So there were problematic areas, and it was high time for a revision as well. But this logic of decolonization, so that remains only as a political propaganda. So when we see the text of the bills, we can see that I would go to the extent of saying that at least 90% of the provisions of the previous laws, the so-called British era laws, are remaining in the new versions as well. The only change is that the arrangement of the sections have been changed, and a new name has been given. So we can easily say that these new laws, which allegedly reform the criminal law justice system. I don't agree to this view that they are reforming. They are not reforming. There is no overhaul. It's just creating confusion. These are just, one can say, just old wine in new bottle. So thematically or subject-wise, there isn't much difference. Few changes are there. These changes could have been introduced through amendments to the existing laws. So now the thing is that now the sections have been rearranged, the names have been changed, but substantively they remain the same. And we have now the judges, the prosecutors, the policemen, everybody are now forced to apply two laws, because for the crimes which existed before July 1, the previous laws will continue and their appeals and trials will continue as per the previous regime. And the crimes and the offences which are happening after July 1, they will take place as per the new laws. So as you all are aware, our criminal law process takes a lot of time. It takes at least, 20 to 30 years for a criminal case to reach its finality at the Supreme Court level in India. So we are seeing the application of these two sets of laws at least for the next 3 decades. And this is going to create a lot of confusion. And already there is a lot of confusion now. Different high courts have already started giving different interpretation as to when as to the date of application of these laws with respect to pending appeals, etc. Within 1 month itself, we have half a dozen of high court judgments taking contrary views. And in the coming days, we are going to see the confusion arising. So that is with respect to the practical aspect. Now coming to the core of our discussion. So when we talk about the impact on dissent, so we have to see that that same colonial logic which was governing the previous criminal law regime, that is continuing in the new criminal laws as well. So one classic example is the example which Procheta cited, that example of sedition. So we had section 124A in the Indian Penal Code. This was introduced during the British time to attack or to quell the freedom movement. And all our freedom fighters like Bal Gangadhar Tilak and even Mahatma Gandhi, they had faced prosecutions under section 124A. And after independence, section 124A was the most abused and misused provisions. This provision was used to attack people who are criticizing the government, journalists who are raising uncomfortable questions, and even cartoonists who are making uncomfortable cartoons. So in last year, so 2 years before, in 2022, the Supreme Court, while taking note of the widespread concerns about the misuse of section 124A, the Supreme Court passed a very landmark direction that this section should be kept in abeyance. The court did not strike it down. That petition is still pending. So the court said that the court initially asked the government to revisit this section. And since no positive response was coming from the government, the court passed a direction that in future, this section should not be invoked. And all the pending trials and proceedings which are invoking the present section, which are charged under section 124A, they are kept in abeyance. So this landmark order was passed. And this petition was kept on, even during the subsequent hearings, the Attorney General himself came and sought for time saying that the government is bringing a new set of criminal law and that will replace sedition. And so when the bill was introduced, the Union Home Minister said that this bill has removed sedition. Yes, that is partly true. If you are thinking we are taking the words in a very literal sense, that is true because we won't see that word sedition in the new bill. But there is a more dangerous provision which has replaced sedition. That is section 152A, the section 152 of the BNS. So section 152 of the BNS that punishes offences which endanger the sovereignty and integrity of the country. So I'll screen share that section so you can yourself see how vague and wide that section is. I'll just screen share it. Yes. So section 152, if you see, so there are many, it's a very widely worded provision. It says that whoever purposely or knowingly by words, either spoken or written, or by signs, or by visible representation, or by electronic communication, or by use of financial means, or otherwise excites or attempts to excite secession or armed rebellion or subversive activities or encourages feelings of separatist activities or endangers sovereignty or unity and integrity of India or indulges in or commit any such act shall be punished with so and so, so and so. So it can cover not only actions, words, signs, even your Facebook post or Twitter, your tweet or your Instagram post or your WhatsApp story, anything which can put the government in an uncomfortable situation. For example, this words like subversive activities. What is a subversive activity? There is no definition. There is no clarity. So tomorrow somebody is protesting against, for example, the CAA or the NRC, or now the farmers' protests are going on, which the government is opposing, which the government wants to crush it down. Like in 2021, we saw the farmers' protest against the 3 farm laws, which went on for almost 1 year, and the government was stoutly opposing the protests. The government even went to the extent of branding the entire protesters as Khalistanis. The CAA protests also, government wanted to crush it down. And many of the CAA protesters, the people who are in the forefront of the protests, they are in jail now under UAPA. So this is the trend which the government has exhibited. And now you are giving a very widely worded provision to the government, to the same government, which has exhibited this tendency to abuse provisions to attack dissenters. So this is like giving a stick to the government to beat you. So for example, subversive activities, this word, the subversive activity, if you see, it can be anything. There is no clarity in the provision. So tomorrow you are organizing a protest against something against the government. So it can be a subversive activity. And now you see the next phrase, encourages feelings of separatist activities. So what is separatist activity? So now, for example, presently there is an ongoing debate regarding, federalism, and many states are complaining that they are being discriminated with respect to financial developments and with respect to distribution of the GST revenue, etc. And even after the latest budget, there were several criticism by many states that they were discriminated. Only 2 states were favored. And this was a very, even social media also, many commoners also raised these opinions. So tomorrow somebody can say that, okay, this can amount to encouraging separatist feelings, separatist activities. So these provisions are very vague and very widely worded. And as per the judgment in the Sreya Singhal case, any vagueness or arbitrariness in the provision, which has a potential for misuse, which has a potential impact on free speech and other fundamental rights, that is unconstitutional, that is arbitrary. That is the judgment of Sreya Singhal, which struck down section 66A of the IT Act, which was also a much abused position. So the same mischief, the same vice is continuing in section 152 as well. So now, now the situation has become much worse. Why I am saying this is because as regards section 124A, we had certain Supreme Court judgments which read the scope of the section, which narrowed the scope of the section. Although, it's a different story that the police people never used to follow the Supreme Court judgments, but at least, in theory, there were certain guidelines. For example, in that 1962 Kedarnath case, where the Supreme Court upheld the constitutionality of 124A, even though the court upheld the constitutionality, the court read it down. The court made a very important clarification that a mere speech will not amount to sedition. It has to be accompanied by some activity which has an impact on public order. So this important condition was read into the section by the Supreme Court in that Kedarnath case. And this was later applied in the Balwant Singh case. So in that Balwant Singh case, what happened was that certain persons, they were accused of raising pro-Khalistani slogans. But the court did not convict them. The court said that, okay, even though the slogans might be problematic, but apart from raising slogans, they did not do anything. There was no other act which accompanied the sloganeering. So the court said that a mere act of sloganeering, that will not amount to sedition. So there has to be some other manifest act which has which has an impact on public order or which can lead to incitement of violence. So at least that safeguard was there. So this judicial interpretation was there. But as I said, I mean, the police never cared about these judicial interpretation. So we have seen the random and arbitrary invocation of Section 124A, not only against journalists and cartoonists, even against commoners. So I remember there was a case, after an India-Pakistan cricket match. So certain Kashmiri students were slapped with sedition by saying on the allegation that they had cheered for Pakistan. Somebody was charged with sedition on the ground that there was some WhatsApp message. There was a WhatsApp message which wished Happy Independence Day to both Pakistan and India. And this case was later quashed by the Supreme Court. So common people are also getting targeted by the invocation of Section 124A. So despite the judicial interpretations, we saw a very rampant and even, I would say, even ridiculous, but that word might not be appropriate because people are actually suffering because of that section. So we have that history. So we have that history of a government which has shown the tendency to abuse positions. We have the history of police forces of all states, of all political realms, who have shown the tendency to disregard judicial opinions and judicial interpretations, and who have faced no accountability. So I suggest that there is a study done by Article 14. So I'll screen share that as well. So I recommend this article for your reading. It's a very good research on the application of sedition, 124A, a decade of darkness. So they have analyzed the sedition cases from 2010 itself. So they have analyzed, and it's a good read, that article. So once you read that article, you would know that how randomly and how arbitrarily this section was used. So now coming to the new provision. So this new provision, at least, if the government was committed to protect the fundamental rights and safeguard the civil liberties of the citizens, then the least the government should have done was to ensure that the interpretation given by the Supreme Court in the Kedarnath case, that interpretation at least should have been included in this provision as a proviso. That condition should have been incorporated. Now what happens is that since it's a new provision, tomorrow the prosecution will argue that this interpretation of Kedarnath will not apply here. So even that safeguard which was given by Kedarnath judgment, even that minimum safeguard, that is now taken away. So that is the problem. So that's why I'm saying we are staring at a much worse problem now. So now the defense given by the government is that, so what in the previous section, in section 124A, the words used were whoever creating disaffection against the government. That was the word. Now in the new section, that word government is not there. It has been replaced by India. So you can criticize the government, so you are safe, but you can't act against the country. That is the interpretation given by the government. In my view, this interpretation in practical terms is not going to make any guarantee. Because, as I mentioned, we have seen the trend of police forces and the governments, and the distinction between government and the country are often that has been narrowed down. That it's a very blurred line now. So whoever is speaking against the government, it's automatically seen as speaking against the country. So this provision is much more dangerous now, and even the whatever judicial safeguards we had, even that is lost now. So this is going to be creating a very grave, chilling effect on our right to dissent. Now I'll come to another problematic section. That is section 113. So I'll screenshot that. Okay. So section 113. So this is a provision. This is the Offence of Terrorist Act. Okay. Just a second. Okay, so this is the Offence of Terrorist Act. So you can also, I'm not reading the section in assets, it's a very widely worded, it's a very long provision. So the thing is that, this section is the verbatim copy of the Offence of Terrorist Act, which is defined under the UAPA, Unlawful Activities Prevention Act. So the same wordings, the same provision has been lifted and has been put in the BNS. So a very basic question stares at us. When you have one provision, when you have a special enactment to deal with terrorist act, what is the need to, copy that, the same section and incorporate the same under the general law, the BNS? So now this is going to create a lot of confusion and a lot of problems. So this terrorist act, this definition of terrorist act is very wide. It's not just merely, planting a bomb and killing people. That is the, our conventional understanding of a terrorist act. When we say terrorist act, this is the image which everyone will have in their mind. But this definition, this legal definition is very wide. So there are words like, anything which affects the economic security of the country. So, and in the definition, what they say is that, I'll just show that portion. So in the definition, what they say is that, so what is an act which can affect the economic security of the country? So there are several clauses given. So there is one interesting clause. I'm not saying interesting in the sense, this is a clause which needs a much more scrutiny. So it reads as, disruption of any supplies or services essential to the life of the community. So the problem with this section is that, so for example, tomorrow a group of people, they are protesting. Now the farmers are protesting at the highway border, the Punjab-Haryana border. So the highway is blocked. So now tomorrow the government can say, okay, they are blocking the highway. So they are disrupting the essential supplies. So they are terrorists. So they are committing a terrorist act. So they can be charged under this section. So they can be branded as, what the government and the affiliated people, they are unofficially calling them terrorists already. So now they can legally call them terrorists. So all these modes of protest, we have protests of rail roko, etc. See, these are offenses. There is no doubt about that. You are blocking a highway, that's an offense. Under the Highways Act, that's an offense. You are blocking a railway line, that's an offense under the Railways Act. So all modes of protests are in one way or another a violation of law. Without violating law, you can't protest as such. So that is the, even our freedom struggle, the civil disobedience movement led by Mahatma Gandhi, that was a violation of law. So what happens is that, when technically these are violations of law, but when they are articulating a cause which has a popular appeal and which resonates with people, sometimes the government will change their position. So when the farmers' protest was going on against the farmers for the 3 farm bills, it went on for almost 1 year. Ultimately, what the government did, the government retracted the laws. So the government had to do that reluctantly because the government felt that their protest was gathering momentum. It was gathering popular support. So now the impact of these kind of provisions is that, so it can completely deter people from protesting. So we saw when the CA was enacted and the proposal to NRC was made, we saw massive gatherings of people, common people who are not like, political people. Common people gathered in all cities. We saw protests in Mumbai, Bangalore, Delhi, everywhere. So these were common people gathering, they were assembling in the roads and, making a gathering, etc. Of course, they were also blocking roads. So with this section, they can be branded as terrorists now. So, and another problem is that, see, we call the UAPA a very draconian law, and for right reasons as well. Because, we have a very wide definition of terrorism. And once you are arrested, getting a bail is a near impossibility because of the statutory rigor under section 43DF, you have to make a prima facie case that there is no evidence against you, and that, getting a bail is a near impossibility. The only people who got bail in UAPA cases, if we do a study, is that people who spent several years in custody, 5 years or 8 years, etc. After several years, the Supreme Court grants them bail, saying that, okay, there is a prolonged custody. Otherwise, getting bail on merits in a UAPA case is a near impossibility. But nevertheless, even if we call UAPA a draconian law, there were certain safeguards, certain minimum safeguards. Okay, so for example, like the UAPA case, an FIR under the UAPA can be registered only by a senior officer. An SHO cannot register. An SP level officer can register. And even after the case is registered, there has to be an independent evaluation by a committee. There is a UAPA review committee constituted by the government, and that committee is headed by a retired High Court judge. So this committee has to verify the FIR and other facts, etc. And they have to give a clearance for the case. And even for the prosecution to start, you have to obtain sanction from the government. Okay, so, although these things do not really, in many cases, these provisions do not mean any safeguard assets, but still, at least on paper, we had some safeguards. It was not easy too easy to invoke UAP assets. You had to go through these processes. Okay. So, but now, what happens is that this provision of Terrorist Act in the BNS, of course, the BNS provision also says that this FIR can be registered only by an officer at the level of SP. That is there. But what the curious aspect is that they have included this provision under this chapter relating to offenses against human body. That's a very curious placement. So you can see that this provision is included in this chapter 6, offenses affecting human body. Ideally, this chapter, going by this theme of BNS, this should have been placed along with the offenses relating to sedition, this 152, etc. That is in the chapter 7, offenses against state. So now you might think why this provision has been kept under this chapter, this chapter 6. So you will get this answer when you read BNSS, the Bharatiya Nagarik Suraksha Sanhita. So in BNSS, there is a provision which says that to prosecute, you need prior sanction to initiate prosecution for offenses which are falling under chapter 7, that is, which are the offenses against the state. That is like, your sedition, the new avatar of sedition, etc. But since this offense of Terrorist Act is placed under chapter 6, this requirement of sanction is not there. So now the intention of the government is now very clear. They have very deliberately placed this, taken out this offense of Terrorist Act out of chapter 7, so that they don't need to wait for this sanction, that requirement of, so that they can circumvent this requirement of sanction. So now what happens is that now, at least, as I said, since there were some procedural checks under the UAPA, it was not easy, we never saw the invocation of UAPA in everyday cases. But now, under the BNS, now since it has come under the BNS, its invocation is become easy. So it can be invoked in regular cases as well. So this can also cause a lot of chilling effect, as well as confusions as well. And the basic question, why do you need the same provisions in the both laws? Once there is a special statute, it's a basic principle of statutory interpretation that once there is a special statute, that will govern. Now you have a special statute to deal with unlawful activities, the UAPA. So what is the need to incorporate that under the general legislation? It's a very basic question. But now, since when initially I thought this was just over enthusiasm, but now when we see this placement of sections as well, and see, terrorist act, need not be placed under chapter 6 assets. Going by its theme, it should have been in chapter 7. So I think it was deliberately done to circumvent this sanction requirement. So now, and again, I am not elaborating much on the other provisions. You have this provision relating to organized crime, that is section 112. That is also very vaguely worded. To deal with organized crime, we have special statutes in almost all the states. Maharashtra has, Gujarat has, and in other states, it's other versions are there to deal with goons and other people who are regularly indulging in crimes. But now a vaguely worded provision has been included under the BNS as well. So these are the substantive provisions which can create a very chilling effect on our right to free speech and on our right to question the government. Now coming to some other problematic provisions of the BNSs. So regarding this police custody provision, there is a lot of discussion. You must be also aware of the discussions which happened regarding police custody. So that is section 187. So the Home Minister has clarified that section 187 does not intend to increase the police custody period beyond 15 days. And Home Minister has said that the intention was that this police custody can be taken beyond the initial period of 15 days in several installments. Like, you can take police custody for 2 days or 3 days, etc. But its total cap should not exceed 15 days. So this was the interpretation given by the Home Minister. And this interpretation seems to be flowing from the section also. But the problem is that, in the proviso of this section 187, one crucial word, in the corresponding version, in the CRPC, in the section 167 of the CRPC. So in the proviso, there were certain important words which stated that, so when a magistrate grants custody, after the first 15 days of arrest, it should be otherwise than in police custody. So these words, otherwise than in police custody, were there in section 167. But for some reason, these words, otherwise than in police custody, these words are missing from section 187. So the impact is that, when you read the section, when you read the first section, the first subsection, that seems to be in alignment with what the Home Minister also said. That, the section's intention is that police custody should be can be brought in different installments, but overall the cap should be 15 days. But when we read the next section, since these words, otherwise than in police custody, these words are not there, it is possible to interpret that the magistrate can grant police custody for the entire period of 60 days or 90 days, whatever, as the case may be. So there is an inherent contradiction in the wording of the section itself. So I don't know whether it was due to some oversight or was it deliberately done, whatever be it. Since it's a very crucial provision which has a bearing on one's personal liberty, there should have been a lot of care and circumspection while drafting this section. But that is unfortunately missing. And it gives scope for an interpretation that police custody can be taken for the entire period. Now, what is the consequence of police custody? When a person is placed under police custody, there is no judicial oversight. So, there are chances of torture or third-degree measures, etc. happening. So, when a person is sent to judicial custody, he is sent to the jail. So, there are some layers of protection. So, now there is a scope for interpreting that police custody can be sought for the entire period. That's a very dangerous interpretation, I hope. So, and there are other provisions like, handcuffing. Handcuffing was declared to be unconstitutional by the Supreme Court by Justice V.R. Krishna way back. And the court said that it should be done only in exceptional cases. But now the new provision in the BNSS, it allows for handcuffing in all cases. So handcuffing has become the norm. And again, you have provisions like the people, for example, every police station should display the list of persons who are arrested. So that provision was there in the CRPC as well, but that was there in the notice board of the police station. But now there is a requirement that should be electronically displayed as well. So, it is available online as well. So somebody searches you are doing a Google search of your name and you are arrested in some case, and suddenly that will pop up. So that can also create problems. So these are the broad points of concern which I have with respect to BNSS and as well as the BNSS. These provisions can create a lot of chilling effect on free speech. And if the government was really committed to protecting civil liberties and was really committed to decolonizing, then they would have drafted these provisions in a different manner instead of merely copying the previous provisions. And the manner in which they drafted this 152A and the manner in which they disregarded the judicial interpretations as well. So that shows that the government has very less regard for civil liberties, and the government wants to keep this power of abuse with themselves to control people's voices and opinions. So these are the brief words I have to say. Now we can maybe have a discussion for a while.
Yeah, thank you, Manu. It was actually wonderful. So I am actually a student of law. I'm in my second year of my LLM. I'm Jay Mani. I forgot introducing myself initially.
Oh, I'm sorry. I saw your
display. That was my mistake. I did not introduce myself.
I'm sorry.
Yeah.
Okay.
Our audience today, they are not just like law students, but there are a lot of others as well from other background. And I think it was like really useful. It is not just only the legal jargons like every other event that we go for. It was like very clear for the general public. And it was actually a well-researched one. Like, we will try to share the Decade of Darkness database of Article 14 with our audience as well. And like, now we might open the session. We'll open the Q&A session. So if people are interested, maybe you can actually raise your hand. Like, raise your hand option is there. So now also we are sharing a Google form for the attendance in case we are having in case you want to follow our other events as well. Like, we're sharing it in the text box. Please check that out. And like, yeah, please raise your hand so that you can ask questions. Yeah, we'll take a maximum of 3 questions. Yeah, please, can you please take write it in the text box. Yeah, Ayushi, you can actually go ahead. Ayushi Gupta.
Hello, am I audible?
Yes.
Hi, sir. Thank you for this session. It was a very productive one. So I have a bit of a question that you talked about the provisions of I think it was 113 about the terrorist act and the activities that are already covered in some terrorist act governing the legislation. So what? And also about the UAPA thing that is already covered under the UAPA Act, but it is now also been in the BNS Act. So, if there is a case about the same provisions, the special act would govern the act. But now, if this is also covered in BNS, what would it be what would be the significance of this? inevitably the special act should cover this act of a person. But since it is also covered in the BNS, what significance and what justification is there for this? I would like to ask. Thank you.
See, Ayushi, even that is a potential area of confusion. See, if the case is registered under the BNS, then the trial and everything will go as per the BNSS. Okay. But if a case is registered under the UAPA, the trial cannot go to the regular court. It can go only to the special court, a court which has been designated as a special UAPA court. And also the thing is that, if a case is under UAPA, for the bail provisions, that will be governed by Section 43DF of the UAPA, which has some stringent conditions. But if the case is under the BNS, then naturally the bail will be governed by BNSS, which is a normal provision. So for that, if there are two people, one person is charged under UAPA, then that accused will be facing difficulties in getting bail. But another person who is also charged with the same terrorist act, the same wording, etc., but under the BNS, for that person, bail is slightly easier because BNSS does not have that statutory rigors of the UAPA. So that is a classic case of discrimination and arbitrariness, in my view. Because saying, two equally standing, two people who are equally in the equal footing, they are treated differently. One person has to satisfy that there is no prima facie case. Other person does not have to go to that extent. So it's clear arbitrariness, and I believe that this will be challenged and this should be struck down, and so that confusion will anyway arise. And then again, somebody might argue that even though the case is under the BNS, the provisions of UAPA should apply because that's a special law. That interpretation is also possible. So we are staring at a very potential mine of confusions. It's going to be a very Pandora's box, I would say. So no one can be sure about what is going to happen.
Also, sir, is the thing is which will prevail over other? This confusion could also be there.
Sure. See, generally, the special statute should prevail over the general statute. That is the general law of interpretation. But in a specific case like this, what can happen that we have to wait for a specific case.
Thank you, sir.
Yeah. Now we also have a question in the chat box, and we have Deepa. Maybe after the chat box question, we'll go to Deepa's. Vivek Mishra has asked this question about BNSS. So he has spoken about the judgments, especially Lalita Kumari case, DK Basu, when it comes for the arrest guidelines. So, which you actually answered, the bail and its relation. So with Lalita Kumari's case, it is also about FIR. When we look at BNSS, in section 173, we have this preliminary inquiry.
Correct.
So this preliminary inquiry is actually a very colonial, in fact, it was there in the colonial government's provision, which is brought in again. So in that case, this actually provides a huge leap of powers to the police when it comes to inquiry, which is the ED's powers when it comes to Prevention of Corruption Act. So with Lalita Kumari's case in this, can we make a connection to it, Manu?
See, Lalita Kumari case has been overruled by BNSS, by section 173. Because Lalita Kumari said that whenever there is a cognizable offense, police has to register FIR. They can go for preliminary inquiry only in certain specified cases. So the Lalita Kumari judgment specified the cases where preliminary inquiry was possible, like cases under the Prevention of Corruption Act, medical negligence, or matrimonial issues, or pure contractual issues. So the judgment had specified. So in all other cases, you should register FIR without doing any preliminary inquiry. This was the ruling in Lalita Kumari. Now your section 173 of BNSS has nullified the Supreme Court judgment. Lalita Kumari is no longer relevant under the BNSS. So forget about Lalita Kumari. So now under the BNSS, wherever an offense is punishable less than 7 years, preliminary inquiry is the norm. So police will do preliminary inquiry, and so that actually what it means in practical terms is that getting an FIR registered has become tougher now. Now you go to police station and you are a person from a vulnerable background, or a person who is lacking in social connections and social capital, and you are lodging an FIR against someone who is influential. The police won't be registering FIR. And they, in the name of preliminary inquiry, etc., they'll be doing, some settlement effects, and all those things can happen. So it is giving police that kind of discretion is very dangerous. And the Supreme Court recognized this danger. That is why in Lalita Kumari, the court strictly said no preliminary inquiry. Because giving police that kind of discretion, that can be abused, and a lot of corruption and a lot of things can happen even before the stage of FIR. So this is a very dangerous provision, and it's a regressive provision, I would say.
Yeah, yes, Manu, true. That is actually the thing. So now we have Deepa. Deepa, you can ask a question.
Am I audible?
Yes.
Yeah, thank you for this session. And it was really a very enlightening session. So I would like to add something. Like recently, there was a broadcasting regulation bill, which we have seen. Means it is a kind of like the things which we see on YouTube, or the podcast which is there on YouTube. These all things are going to be regulated. So somewhere or the other means there is a curtail, means they are curtailing the freedom of speech. But at the same time, since you have talked about farm bill, so the former Niti Aayog CEO of Niti Aayog, Amitabh Kant, has said that India is suffering from excessive democracy. So at this means how, like, when we need a reform in a country, so he actually said that it is very difficult to go for a reform. Because we are suffering from very excessive democracy. So at the same time, like, how will we balance the freedom of speech and where the line has to be drawn between the freedom of speech and the exceptions? How we'll go towards these exceptions?
See, our constitution itself has specified the grounds on which free speech can be regulated. We have Article 19(2). There are specified grounds, and reasonable restrictions can be imposed. And the thing is that the restriction should be reasonable. So these provisions, in my talk, I tried to demonstrate that how unreasonable these provisions are. If the provisions are wide and vague and arbitrary, then it cannot be reasonable. So these would be unreasonable restrictions. So that test of reasonableness, they are not meeting these provisions. So of course, the government can regulate. We don't have absolute free speech. We don't have a free speech jurisprudence like the United States has. We have this regime of reasonable restrictions, and that is also necessary. I completely agree with that. There should be some regulations, but these BNSS provisions and the BNS provisions, they are not meeting that test of reasonableness. That is my view, and this I was trying to demonstrate in my talk as well.
Yeah, thank you.
Yeah, thank you. I think a similar question was also asked by Shamali Banerjee, which I think this answer would actually suffice.
And one more thing I just want to add. So now the broadcasting bill has not come as such. So what the government has done is that they have, last year they released a draft for public consultation. And that draft proposed to include even social media content creators, etc. And now the government has come up with another draft, but this draft has not come in public domain as such. But there are certain reports that these drafts, the new draft seeks to impose more regulations on individual content creators as well. So people like Dhruv Rathi or Ravish Kumar, etc., YouTubers, and even Instagram influencers, etc., they are trying to be regulated. But this draft has not officially come in the public domain. So it has not reached the stage of bill as such. But again, of course, I mean, it's very concerning. This movie is very concerning. But I believe that's a topic for another day. Right?
Yeah. Thank you, Manu. And also, when we look at this whole year has been, the political climate has been very different. Like, we had the campus crackdowns in Colombia, the protests against Palestine. Around the world, the political climate has been very regressive. So in such a scenario, like recently we had in Bangladesh, whatever the situation is. So in that case, it has been very regressive. So we have one of our friends who would be asking something. He's actually from Bangladesh, so it would be very great. Like, we would like to entertain that as well. Yeah.
Hi, sir. Myself, Saleh Sadiq. I'm from Bangladesh. So, Germany has already put the context that I'm trying to bring into that. So, while you are discussing about this sedition kind of thing, so I don't recall the exact wording, but I have seen that in one of the provision there was this kind of write-up, which actually what I got to understand, that if there are some foreign government or foreign country with which India has a close tie or very good relations, and if some Indian citizens who do some sort of activities that may not be actually at the behest of that foreign country's interest, or that can be termed as a deteriorating act in between these two governments. So in that context, we have seen that during this current movement, student-led movement, which actually started with the demand for a reservations reform for the reservation or quota system in Bangladesh. Now that turned into the one-point demand for the resignation of current regime. And we have also got so many solidarities from across the world, especially our Indian students community. So could there be any chance that in near future, whenever students come forward with any sort of solidarity statements or any sort of demonstration at their homeland for what is happening with another country, like for the case of Bangladesh, they can be charged into this kind of sedition act?
Right. See, Sadiq, what you said is correct. So there is a provision. So this provision was there in the IPC as well, the Indian Penal Code as well. So that is section 153 and 154, which say that, waging war against government of any foreign state at peace with the government of India. So that provision, it's when we see the wordings, so the provision seeks to deal with activities which are violent against any other state which has friendly relations with India. So that is the section. So the same was there in the IPC as well. But the thing is that we have not seen much cases in India with respect to this section as such as of now. Its invocation is very rare. So we don't have much cases as such under this section as well. So under the previous IPC also this provision was there. Essentially, this was inserted by the British. So British, they had several colonies across the country, across the world. So what they wanted was, to preserve the dominions across the world. So they didn't want any Indian to attack any British colony in Africa or elsewhere. So, but after the independence, the wordings were changed and, this was substituted with friendly countries. So this provision has also a colonial origin, and that is continuing. So the continuation or the retention of the same section is another indication of the colonial logic also, one can say. again, possible, but we can't say anything as of now. The thing is that, we haven't seen any concrete cases as such under this section. It's very rarely invoked. Personally speaking, I haven't seen. So I haven't come across any reports also regarding this section. So we have to see what can happen.
Thank you, sir.
Yeah.
Thank you, Manu, for answering the question. Do we have any more questions? So I think there aren't any. Thank you, Manu. It was actually a very wonderful session. So, or whenever we talk about free speech, we always consider free speech to be the cornerstone of democracy. So, and the criminal laws are, in fact, the most important ones which should be discussed upon. And we had a wonderful session with you. And you are there in legal journalism, and how, journalism is like, journalists are always targeted when it comes to speech, when it comes to critique of the government. So it was wonderful. So now we have Pracheta for vote of thanks. Now, yes, I'll leave the thing to Pracheta.
Hello, everyone. So we are from PSG. We wanted to thank everyone for attending the session. Thank you, Jayamani, so much for moderating the event. Thank you, Manu, for coming and speaking to us. We hope that in the near future, you can be again. We can have more discussions regarding this topic. Thank you, Madhuvani and Jacob, for organizing the event, and thank you, Anand, for contacting Manu. And thank you everyone for attending the session. Thank you so much. It was really lovely having you.
Thank you. It was my privilege and pleasure as well. I enjoyed this interaction with all of you. Thank you. Have a good weekend.
Thank you.